Can you imagine? In fact, this is interesting, and this is the kind of news we want to be hearing in this country, because I don't understand. Now, a judge has sentenced a professor to 3 years imprisonment for forcing an election result in 2019, which is interesting because when irregularities is allowed to happen constantly without repercussion, it will gradually turn into a tradition, which has never helped us to grow or develop better as a developing country. And I don't understand why a full professor will stoop so low, accept to deceive and destroy people's mandate by switching election result from what it is to what it is not and was never meant to be. Now news have it that Professor Ignatius Uduak performed this act in 2019 and the legal action started in 2020, but the case has delayed because of some certain issue ranging from him pleading not guilty, changing his legal defense counsel at some extent, even collapsing when he was called for cross-examination, which is their usual trick. But the judge said Nehigaba said lie, he must face the dance of what he has caused. That is 2 seconds. Bay on Wednesday, he was slammed 3 years imprisonment. Now he is not the first person that has collected this. So another of his colleagues collected the same 3 years imprisonment in 2021. And I pray that this same news and this same action should extend to their camp, which is their headquarters. Because if you don't, we are just scratching the surface. And until it does, you will understand that this is part of the major issues we are passing through in this country. Because I don't understand how somebody will assure you, spend taxpayers' money, and after, you will not see any dividends of the assurance, and you will be allowed to be moving freely like nothing is happening. But anyway, let me allow you to listen to the lawyers concerning the case and see what is going on. But as you are listening, be clicking on that share button and also subscribe in case if you have never done so for more update. And after that, I will be back. Let's go there.
Relates to 2019 general elections and not 2023. And it was one of the cases initiated by the former INEC Commissioner in Akwa Ibom State, Honorable Mike Igini, with the support of his chairman against those that committed infractions against the system. And this judgment delivered this morning is very incisive, detailed, and we commend the courage of the judge at least for taking it this far. It has taken us 5 years to prosecute Professor Ignatius Uduak for the offenses he committed against the state. And this judgment is going to serve as deterrence to others that may be engaged tomorrow by INEC to help ensure credibility of the electoral process, but who turn around to sabotage it for selfish and worldly reasons. You've seen the entirety of the judgment. He was convicted for publishing false election results and also for perjury. And what happened in this case was a very sad thing, and his conduct particularly is a disservice to the cause of democracy in our country, and if I may say, it's a reproachable breach of trust against INEC, who paid him for this job, but he ended up sabotaging. You heard it all from the judgment today. On the 10th of March 2019, Yadelia submitted a handwritten note detailing the incident at the election, how himself was chased away from the collation center, and that he was forced to announce a result. But less than 24 hours later, he generated another result. He came up with the official final result, now declaring a winner for the election. He returned the winner for an election that there was no collation in any of the levels. There was no collation from the polling units. There was no collation from the ward levels. There was no collation at the local government level before it got to him as returning officer. But yet the professor made a return for that election and had the audacity to appear before the election tribunal to validate that same false election results. He was invited by INEC to come forward to justify his declaration. He only threatened to take INEC to court. Then INEC now filed this charge against him, and he escaped. As it stands today, there were 2 bench warrants issued by this court against him before we could procure him. First was before his arraignment itself. There was the bench warrant. In the course of the trial, he refused to attend cover several occasions, and procured a forged medical report from Lagos State University saying that he was sick. It took the efforts of the Commissioner of Police in Lagos State to verify the authenticity of that medical report, and it turned out from the police report that he was never anywhere near Lagos on those days he claimed, and that the doctor he claimed issued in the medical report never existed in the payroll of the university teaching hospital. So we have been through a lot. So from what you had the judge said today, if you had maintained Exhibit A, INEC would have taken him as an honorable man for stating the truth. It's a very sad note, and this particular judgment should act as a springboard for future elections, and as a warning to other lecturers in our every-tours who may be engaged tomorrow, yes, that if they ever falsify, manipulate the system, a day of reckoning will come, as it has come today for Professor Ignatius Oduk.
Litigation of this nature is federal government is involved, so you need to do your best to establish your case before the court, which is what we have done. You can do your own part, but you are not the one to determine how the judge is going to look at it. Today the judge have looked at it, even where he favored us. He said he favored us. Where it was not favoring us, he said so. And he proceeded with the judgment, which I'm not against. The prosecution were very clever and smart while preparing the charge. The law they relied on is the same law that created the offense for announcement and publication. They choose to make announcement count 1 and push publication count 2. Now, while the judge was looking at the matter as we have finished, he looked at the totality of evidence in court, and the judge found out that even the document produced by the prosecution exonerated the defendant. The document they produced, where it was stated that he was compelled to announce. So that compelling him to announce by law, he cannot be held liable because he didn't do it intentionally. That's what the judge said. And that affects only count 1. And that was why he was exonerated in count 1. Now, coming to count 2, which is now publication, the judge was now asking the question, can it be said that compelling him to announce also push him to go and publish it? So the judge said no. As at the point of going to publish it, that is sending the record to INEC, he's no longer being compelled. That was why he said count 2 remains, that he's found guilty in count 2. Then coming to count 3, which is perjury, on our own part, we maintain our ground that what we said to tribunal was the truth. We came to the court, we repeated that's the truth as we know. But from the understanding of the judge, that truth is falsehood. So we are not going to challenge the court on that until we see the judgment and look at the things that the judge looked at before coming to that conclusion. If it's what proceeding from here to on appeal, that's my work. I proceed. If I look at it, it doesn't worth it. It's just one of the cases. We keep the file and continue with others.
You get the point. Now, what do you think about this news? Where else do you want this same news and this same action to get to in this country? Because I know that you truly want the same action to get to some certain sectors in this country. In fact, share your thought with me on the comment section. And of course, you know the vibe now. Click on that subscribe button, follow and share for more update. Because like this,